be here and be able to share with you this evening the legal landscape of fracking, but a little bigger than that, the legal landscape of Michigan's history of environmental laws, as well as the common law. So you have common law statutes that the legislature passes, and a little bit on federal law, so that you'll have kind of a general idea of what the landscape is on fracking, but oil and gas in general. I think one thing that's happened with the unconventional oil and gas issues, the fracking issue, is that there's sort of an implied assumption that everything else is okay. And I think, as you can see from Dr. Grobel's presentation, that's not the case. It isn't a situation where we should be relaxing present oil and gas regulations and standards, but it's a situation where they should be ratcheted up for the hydrofracking. And as you'll see, it's actually, one could argue that it's actually moving the other way. We're actually, the more unconventional, the more we need energy on the planet, and the more unconventional energy sources we seek because of the demand and money, the more careless we are. And so we all are part of this. But when I say we, it's who we elect and who passes laws or refuses to pass laws that bring about the risk and the dangers and the harms of having regulations that are not up to speed. So we're going to do, first thing we're going to do is sort of take a, put your whitewater jackets on. I'm going to use this because I've been talking a lot the last few days. I can pop this out without breaking it. And I think there were some that couldn't hear, so yeah, I'll do it. Well, so the roots of water law, I'm going to start with water law real quick. Goes back to 2,000 years almost, Rome. Water is a commons. It's always been public. When you own property, like a landowner, or you live on a lake, like lots of you do. How many live on a lake? Oh, geez. Okay. So it defines your lives. You have a right to use that water, but it is the public's, and the state has an obligation to protect that for you and others, being your residents, fellow residents in the state of Michigan. The principle was carried forward through the Magna Carta, and it came to this country in 1821, where you can see common to all citizens. So the basic idea of property came down to us out of English common law, so other than a few states that were settled by the French. But basically the idea of property can be conveyed by deed, and you own it exclusively, rights of possession and sale and conveyance and inheritance, all that stuff. Whereas water came down as a commons to the state. They hold it, and people have a right to use it, subject to the rights of everyone. Well, when it comes to Great Lakes waters and lakes and streams that are navigable, like Payne Lake and Gun Lake, in those situations, what you end up with is a special kind of water called public trust water. And just to give you an example, and I'm saying this because hydrofracking, as you've seen from the previous speakers, involves either groundwater or surface water removal and/or discharge, with the hydrologic connection risk, if not studied properly, of affecting those bodies of water either in quality or quantity. So I'm raising this so you understand the basic structure here. The public trust means that it can't be diverted for primarily private purposes. It can't be impaired, and the right of the public and those of you who are riparians and share the use of a lake like Payne Lake or Gun Lake, that can't be subordinated to private interests. The state can't do it, and another person can't do it. So that's kind of the basis. Then we run into, I'm just going to skip over some of this, the law of lakes and streams. Those of you who live in a lake, you know it's riparian. Lakes technically are littoral, but we call it riparian. And the basic law is reasonable use in relation to other users in the public. No one can can unreasonably interfere or impair with public or another's use. So, you know, we've got long-standing rules to get along. And when you don't get along, it's enforceable directly by courts. You don't have to go to an agency and get an adverse decision and then have a hard time appealing it. So it's a direct way to protect your property and use of water. Lastly, very interesting in Michigan, No diversion or transfer of water out of a watershed if it diminishes the flow or level. Look at that. The integrity of flows and levels of navigable lakes and streams, actually any lake or stream, if you're a riparian landowner, cannot be diminished by any diversion or withdrawal out of the watershed. Okay? Now, you're going to see a little change in that and be somewhat upset in a minute with the Nestle bottled water case as to what happened to that rule. But that's the Michigan Supreme Court rule. Those cases, that's the rule in Michigan. So groundwater, not in the eastern U.S., we're kind of the reasonable use or American rule, the second one. Very similar to riparian rights. You can't unreasonably interfere with your neighbor's use of their well water. But this has an interesting, these are the other ones are the different rights or law in other states. I'm not going to go there in light of the time. Michigan has kind of a blend between reasonable use and correlative rights, both of which have this rule. If you look here, reasonable use does not prevent the use of waters, okay, distribution for sale, not connected with the ownership or enjoyment, if the owner of the adjacent land is, if he's not interfered with the right to reasonable user of, and then look at the end, or if his well, springs, or stream are thereby materially diminished in flow. If even a diversion off track or out of a watershed under Michigan Supreme Court law affects the level of a lake or stream or a wetland, I would maintain, it violates Michigan groundwater law. So it's very similar to the riparian law. Why is that important? It's important because flow and level of water from we get all our water mostly from snowpack, and then rainfall too, but a lot of snowpack, and down here I know it's mixed, but you know, lately there's been some good storms running through the southern part of the state. Our base flow in the streams, as I think alluded to by Mike Sheldon with the water assessment tool, the base flow in the summer when it's dry comes from our long-term snowmelt and rainfall precipitation. This is very rough, but roughly Michigan gets anywhere from 30 to 32, 33 inches a year, and it varies beyond that, but that's basically the range. About a third of that gets into groundwater. Okay, it becomes groundwater. So climate change can affect this as well. So while about a third gets in, when climate change affects precipitation, it doesn't get to groundwater, it goes to surface water and into Lake Michigan because of warmer winters. Then you have, and higher evaporation, then you begin to have another set of problems because that 1/3 to groundwater is 1/3 of 27, let's say, which is 9 inches, or 1/3 of 24, which is 8. Do inches matter? In the Nestle case, a drop by an inch dried up a large section of a stream because of its morphology, its shape and depth, almost entirely, okay? So yes, withdrawals of water can have a significant impact, local perhaps, but local impacts, particularly on the upstream creeks, water, where the beginning of the watersheds are in the springs, if it's connected to groundwater that's being withdrawn, sooner or later, a gallon out is a gallon out of the lake or stream. In the Nestle case, that was established in the court case, and it was also true in the Anglers of the Asabo case in Otsego County, alluded to by Dr. Grobel. Well, okay, so in the Nestle case, in order to let Nestle get water out of a watershed in bottles for sale, the Court of Appeals changed the law of groundwater. They took away that no effect on flow or level, said it could be severed, and they inserted a balancing test of harm versus of private and public economic and social benefit. So if you're a landowner, just think, if you're being harmed, that can be offset by the goods of others. Doesn't that sound like a takings or something? Yeah? That you're bearing the burden individually of benefits to others. So the court actually shifted burdens here, I think, improperly. The Michigan Supreme Court case, in my view, is still controlling over this issue. Well, okay, the Anglers of the Asabo case. This case extended the Nestle case to lakes and streams in Michigan. So your riparian rights under this case would have been, had it not been vacated and appealed by Anglers. And by the way, one of the anglers of the Asabo's officers and board of directors, Tom Beard, is here tonight. Tom, would you raise your hand in case somebody wants to ask you questions after the meeting? Tom, their organization has been a leading organization in the state. They don't compromise. They're reasonable. They're scientific based, but they, you know, if a stream is to be protected under the law, it's to be protected. Period. Doesn't matter who you are. And I think it's a great tribute to them and to the contribution to the state of Michigan. So ask them questions. They've been through a lot of this. Well, now let's just look. We've talked about, Chris sort of talked about this, but I just want to let you know a little bit about the big picture, energy and food and water worldwide. Because after all, we're feeling that. That's why there was a lease sale. That's why companies are looking at hydrofracking the deeper, tighter shale rock, because there's something going on in the world. What's going on in the world is a massive last gasp effort to, because of the high price of oil, not gas now, but because of the high price of oil, to use hydrofracking at area in rock formations that used to be considered off limits. Same thing with the deep horizon well in the Gulf of Mexico that caused the problem. So there's a huge drive.